Yes, I salute you all. Thanks for listening and thanks for watching. Subscribe to the channel, like the videos and share the videos basically. So basically today we are under contract law, and this is contract law 1, and the topic that we are going to look at is consideration as an element of a valid contract. So basically in many ways we see that for a contract to be valid, there are certain elements that you must apprehend to, and in this essence consideration is one of them basically. And what you have to put in mind is that without a contract that doesn't have consideration, it is not a contract basically. So if it lacks this element, then that contract is not valid. And before even we have defined a contract from Section 1 of the Contract Act to Section 1, an agreement enforceable by law, and Section 1 directs you to Section 9 of the Contracts Act, whereby there they give a broad definition on what a contract is. So basically in this essence, all what we look at is that under Section 9 they give you that this is a contract that is made under free will with a valid consideration and a lawful object basically, and with the intention in that definition in Section 1 they try to place the elements of a valid contract into that definition basically. You can refer to your Section 1. So basically today we are under, and the good case that defines what a contract is, the case of Greenbot, the case of Greenbot versus City Council of Kampala, Greenbot Entertainment Limited versus City Council of Kampala. So that is a good case that can define what a contract means. So basically here we shall see Section 1 still that defines what consideration is. You get Section 1 defines what consideration is. Before we are going to know what consideration is, that however much Section 1 of the Contract Act defines what consideration means, whereby Section 1 for it defines, or it defines, I can read it verbatively, it defines a contract to mean, defines consideration to mean a right, interest, profit or benefit accruing to one party, or forbearance, detriment, loss or responsibility given, suffered or undertaken by the other party. So in brief, consideration, this is where one party gets a benefit, another party gets a detriment. So basically that is the key point. One party is benefiting, another party is getting a detriment as a result. So we have the case of Curie versus Misa. The case of Curie versus Misa portrays or highlights what consideration means. That in brief, consideration, one party is benefiting, another party is receiving a detriment. You get, for example, for you, if you go to the shop, you are giving your money and you are receiving something in return. A certain party is benefiting, another party is taking a detriment. A detriment is like a loss or a suffering. You get, so that's consideration to happen. We have two types of consideration basically. However much some people even add past consideration as a type, but me I'll specify the two. We have executory consideration and executed consideration. Those are the two types of consideration that we have. So for executory consideration, this is the exchange of a promise for promise. Basically, the obligations of the parties are to be done in the future. That's why I've said that it is an exchange of a promise for a promise. That is executory. Then executed, this is parties executed their obligations from there and then. For example, you have gone to the shop, you give the tenant money, he gives you the product. That is executed. You have executed the obligations as a result. So basically in that essence, that is executed consideration basically. So after that, we are going to look at the rules governing consideration. That these are the rules that govern consideration. Where they are not available or where they are not present, consideration is not available basically as a result basically. First of all, consideration must not be passed. This is a vital rule that we have all we must bear, all of us. It must not be passed. What do I mean that it must not be passed? For example, we have seen consideration, a party is benefiting, another one is getting a detriment. So in this essence, for you who is benefiting, or the party who is benefiting, you must show it before an act is done to make it passed. For example, I can give a case whereby that if you wash someone's car or vehicle, and after washing someone's vehicle or car, he afterwards comes and says that, you know what, I'm going to pay you maybe 50,000 shillings. So remember, now he has brought his consideration after the work has been done, which means in this essence that makes consideration to be passed. And this rule that we are seeing shows that consideration must not be passed for a contract to be valid, or for there to be good consideration. Consideration must not be passed. So that is the essence there. So in this essence, we have the case of Remarkado. I know we are familiar with that case. Under this case, what this widow went ahead and innovated the house of these children. So after innovating, they was promised a certain sum of money, of which afterwards he was not paid. So when he went to court told them the consideration was passed basically, and the contract that they had entered into, it wasn't a good contract as a result. At the end of the day, there was no good consideration under that case. But however, this rule has exceptions. Of consideration must not be passed. This rule is having exemptions. And one of the exemptions that we can see, or that we can highlight here, one exemption is that where there is a previous request. In this essence, where there is a previous request, there is always good consideration. And what do I mean by previous request? For example, I come to you and I tell you that, could you help me and wash for me my vehicle? Then you say, yeah, it's okay, I'll wash for you the vehicle. Then even if I don't reply, let me just show that even if I don't reply, but then after later in the day, I wash the vehicle. Then I come in and I say that, now the work you have done for me, I'm going to give you a 50K. So in that essence, however much consideration has come after, but it is an exemption. Reason being that there was a previous request that I asked you to wash the vehicle earlier. You get, so I was acting in line with the previous the previous request as a result. So basically that's it. That's one of the exemptions. The first exemption of past consideration, previous request. The second one is business situations. Anything that is done in purposes of business, that thing is good consideration. Anything that is done in purposes of business, it is good consideration. Let me give you an example that, for example, promoters. However much you may not know promoter of a company. Okay, let me give an example that you have gone for a business trip. Maybe you're a marketeer, you are something, or you are something, you are acting in business, and you go to Guru. When you go to Guru on company businesses, however, the money of the company gets done and you touch on, and you use your own money to do company business, you do for your company basically. So when you return back to the company has mandate to give you remuneration. It has to compensate, whether it was aware or not, whether you agreed before or not. It is a matter of telling the company that, you know what, I did this and this was the sum of money that costed me. The company will compensate you because it was under business situations, and the company cannot claim that it was past consideration as a result. So basically that is also, we have the case of recursive. So recursive patents. Under this case, this was a person that had developed the company some years back, the business some years back. So he sold the shares as a result to the people, and he was given some of the, actually he developed the company some time back. So when these owners of the company held the company, he was given a certain share for the work that he had done previously. But however, these people of the company started reclaiming for their share, holding that it was past consideration. But however, what court had to say that the things that he had developed previously, it was under business situations. So, and in this essence, it was good consideration, because it was the work that he done, it was under a business situation. So basically that is the key point there. Then when you go to another exemption, it is bill of exchange. I'll use checks. That checks can actually, for the checks can be they can be honored for a later date or anything, basically for a later liability. So checks, when you read section 25, 26 and 27 of the Bill of Exchange Act, it has that concept that at any time for the check can be issued to someone, that it can be honored to a payment that was, or to the work that was done, or a debt or a liability that was done some time back. For the Bill of Exchange, which are the checks, example, for them they can honor them. They don't look at the element of past consideration, basically. So under past consideration, the general rule is that consideration must not be passed. But however, you have three exemptions. We have the previous request, we have the bill of exchange, we have the business situations, basically. So another rule that I can go to, that consideration must come from the promisee to the promisor. What am I trying to say here? That consideration coming from the promisee to the promisor, it implies that what someone promised, actually, for consideration to be effective, it must have come from the promisee to the promisor. For example, let me give an example. That a promisee is a party that says that a promisee is the person that is being promised something from the promisor. The promisor is someone that promises someone something. And they are telling you that consideration must come from the promisee to the promisor. You get? For example, let me give an example that I tell you that I'm going to wash your vehicle, and you tell me that you are going to pay me 50,000 shillings, which means the person that is offering me 50,000 is the promisee in this essence, and consideration must come from him, not someone else. You get? So in this essence, all what I'm trying to show you here is that for it to be effected, it must have come from the promisee to the promisor as a result. So for example, many times we see that you can do something. Let me give an example that even it is a scenario that if at all someone, you wash a vehicle and I promised you 50,000 and I'm the promisee, but however maybe I die as a result, or someone comes in my steps, that person that has come in my steps, you don't have the mandate to go and effect the consideration. Reason being that it must have come from me. You get? And also another thing is like this. Another thing is like this. If I'm to wash your vehicle, basically, it is not your friend that has to promise me some amount of money, basically, on your behalf. You are the very person that you have to do what? To promise me that sum of money as the promisee. Because in this essence, I promised to wash for you the vehicle, and you have promised me to pay 50,000. So you are the promisee. Someone cannot speak on your behalf. You get? So it must come from you as the promisee, or as the person that I've promised to work for in this essence, or in this regards, basically. So basically, note that in mind. Basically, we have a case. We have a case of Tweedle versus Atkinson. Actually, this case under Tweedle versus Atkinson, this is where they held the principle that for consideration to be valid, it must come from the promisee to the promisor. What is the point of view here? That for you to effect or to enforce that contract, consideration must have come from the what? From the promisee to the promisor as a result, basically. So we also have consideration need to be sufficient but not adequate. That is also another rule. Consideration need to be sufficient or adequate. In this essence, they are trying to show that consideration doesn't need to be a lot. We don't need adequacy. We need something that is just sufficient. And something that is sufficient is something that has value. Something that has a little bit of value in it. That's why we say that for it need to be sufficient, but not adequate. If it has a little value in it, then that is good consideration. You get? That is good consideration. And in this essence, all what you have to bear in mind is that, for example, let me give an example that, you do for me a particular piece of work, and maybe I give you like, I wanted to use a watch, but a watch it has value. Let me give an example. Maybe I give you a pen. Let me give an example, pen. You have done for me the work I promised to give you a pen. So in this essence, the pen in this capacity, we look at it that is something that is sufficient. It has something like, it has an economic value, it has value. In this essence, it has value. So we don't need to bring money, monetary monies, bags of money. No. Anything that has value in it, it can become sufficient consideration. In this essence, basically. And I want you there to use the case of Thomas. Thomas versus Thomas. That is a good case that provided for consideration being sufficient and need not to be adequate, basically. So basically that is the point of view there under that rule. Then you also have that part payment is not good consideration. Part payment is not good consideration. And what do I mean by part payment? Part payment in this essence is that if at all I demand you 100,000 and you give me 50,000 Ugandan shillings, that 50,000, even if we agree that yes, I've agreed, you have given me 50 in the satisfaction of the full debt, your part payment is not good consideration. Sorry for using Uganda, but I can again say that I want my other 50k. I demand you 100, you just give me 50k. Though I agreed that it is the fulfillment of the whole purchase, the whole amount, but now I want the 50. And they can enforce that because part payment is not good consideration. When you read Pino's case lays down that principle that where there is part payment is not good consideration. You get? Part payment is not good consideration. Basically, for you to pay, you must pay the full price, not part payment. However, we shall look at part payment whereby the exemptions to part payment, where part payment is made by a third party, part payment under promissory estoppel, those are all exemption to the general rule in part what? In part payment, basically. So another point that we are going to look at is that performing an existing public duty is not sufficient consideration. Performing an existing public duty is not good consideration. What do I mean here? That where you have a public duty to do and you carry out in expectation of the consideration that is given to you, that consideration is not good consideration. Let me give an example that the police has a public duty to arrest criminals. Then I make a phone call and tell police, please come and arrest this person. I'm going to pay you 100,000. Then the police comes and arrests these persons. Then afterwards, I deny to pay. The police cannot enforce that contract. Reason being that the consideration that I had given them, it wasn't good consideration. Reason being that they had to perform a public duty, which they are ought to do, to arrest what? To arrest criminals as a result. So in this essence, performance of an existing public duty is not good consideration, where consideration is given. You get? So in that essence, it is not what? Good consideration. And we had the case of Collins versus Godfrey. Collins versus Godfrey, where this person was paid to come and give evidence in court. When he came to give evidence in court, remember, when court summons you to give evidence, then that is a public duty that you have to do. It is a public duty that you have to do, which means that consideration given to it is not good consideration, because it is court that has summoned you. Me telling you that I will pay you, it is not, that is not good consideration. You cannot enforce what I've promised to pay you. You get, so that is also key. Then you also have another one, another rules of consideration, where there is what? Where there is performance of a contractual duty. Where there is the performance of a contractual duty. In this essence, or actually even before, to take you back, performance of a public, performance of an existing public duty. We have said that is not good consideration, but however, there is also where the law is kind of lenient, that where a person has a public duty, now he is overworked beyond what he is expected to do, then the consideration given is good consideration. Let me give an example. That I'm a public servant in office, I must leave at 4 p.m. Sorry, at 4 p.m. But however, you request me to work for you, to overwork until 6 p.m. So that time frame after the official time of resigning, that time you have asked me to work, to overwork, then the consideration you give me, it will be good what? Consideration. Just I wanted to make that clear. Then you also have where there is performance of a contractual duty. The consideration given is not good consideration. Contractual duty, that people have contracts, and in their contract there is what they have to do. So anything that you do in your contract expecting consideration given, then that consideration is not good, basically. So where you have a contractual duty to carry out, in this essence, the services you render following the consideration that is given, you cannot enforce that contract in court, because the consideration that is given to you, it is not good consideration as a result. So basically, let's note that in mind. And basically there we have the case of Hartley versus Ponsonby. Hartley versus Ponsonby. Under this case, this was a ship, it was a sailor, the ship captains, whereby they had to sail the ship and they had a contract. So the others abandoned the ship, other captains abandoned, the sailors abandoned. So this one was promised money so that he can reach the ship to its destination. So when he reached, they failed to pay, so he sued. But however, court said that you had a contractual duty to carry out, of which they promised you money on which something that you had to do was in the contract, basically. So the consideration that was given to it was not good consideration. Hence the courts cannot enforce such what? Such contracts, basically. So basically, let's note that in mind. And basically that's the few that I can talk about, the few rules. However much there are many other more rules of consideration, but those are the few rules that I can talk about. Other than that, thank you for listening and thank you for watching. Subscribe to the channel and be on. Thank you.